It's your favorite nurse, Stephanie, and welcome to Plan Senior Moments. This is the podcast that helps you learn how to keep your parents safe, avoid unnecessary hospitalizations, and support them in aging in place with dignity and confidence. Most of my clients come to me during a time of crisis. Mom's in the hospital, things have changed drastically, and suddenly you're scrambling to come up with a plan of care. But it doesn't have to be that way. With each episode, I'll share real-life stories, expert advice, and practical tips so that you can be proactive, not reactive when it comes to senior care. Let's get started. Hello, and welcome to our guests who have tuned in today's episode of Plan Senior Moments. Today, we are joined by Stephanie Bivens, attorney. Ms. Bivens is the founder of a law firm, Bivens and Associates, based in Scottsdale, Arizona. For over 25 years, Ms. Bivens has practiced estate planning, probate, elder law, and special needs planning. She's also an award-winning attorney, speaker, and author. Thank you, Stephanie, for joining us today. So nice to see you.
Great to see you. Thank you so much for having me on your podcast.
You betcha. You know, this is a topic all families want to know more about. So we're going to have many episodes with Ms. Stephanie on to discuss several topics. And today we're going to jump into estate planning documents, right? What estate planning documents do your parents need so that you can help them?
Yeah, so thanks, other Stephanie. So as an estate planning and an elder law attorney, I frequently work with my older clients who are starting to need help with bill paying, medical decision making. And in other situations, I'm working with their adult children or the spouse who is already taking over and needing to provide a lot of support, if not a complete takeover in those areas. And what surprises many families is you do not get to just pay your parents' bills and take over their assets because you are related by blood or marriage. The law does not work that way. So you have to have legal documents in place, particularly with regard to financial management, but it's also critically important that you have the medical directives in. So as I like to say, everyone over the age of 18 as an adult should have some basic estate planning documents in place, but it becomes really important for older adults who statistically are more likely to have a need for somebody to step in and provide help at some point during their lifetime. So we'll talk about the medical directives really quick. So in Arizona and in all states, you want to have a healthcare power of attorney. A healthcare power of attorney is a pretty straightforward legal document. It just specifies in the event you cannot make and communicate your own medical decisions, who gets to do that for you? And I always recommend you name not just one person, but a backup to that person, right? So if you're the adult child listening to this, and let's say you're starting to help mom and dad out with the doctor's appointments, some distilling, gathering information, or maybe mom and dad are really needing you to just make their medical decisions. Maybe they're not always able to give informed consent. Really important to get mom and dad to an attorney that can prepare a valid healthcare power of attorney for your parents. So there's a clear chain of command at the hospital, and there's no question about who gets to direct mom and dad's medical care. Particularly when there's multiple children, you do not want the throwdown dispute in the hospital. And I've been involved in some of those and had to go to court and resolve some of those. I know you've seen them too, Stephanie. So clear chain of command. The living will is another medical directive. And it sounds like a will and it sounds like a living trust, and it is neither of those. The living will is used to give the patient's end of life medical directions and wishes. So I will say 99% of folks that I work with tell me something like they want all the reasonable medical treatment rendered in an attempt to bring them back to an acceptable quality of life. But if they're in an end of life circumstance, it's not likely to be reversed. Medical intervention and treatment has been attempted. Most people say, you know what, I don't want artificial, heroic medical treatment and interventions indefinitely just to prolong quantity of life where there is no quality of life. So that's the point of the living will. That document's really important because it is the way that the patient can make clear to their medical providers and their family what the patient's wishes are. The decision maker, the agent under the healthcare power of attorney, is to follow those written instructions. So the living will gives peace of mind to the decision maker and the family at a very difficult time. I've seen situations where there's been conflict in the family, and as soon as the living will is presented, then there's no conflict. There's no question. What would mom or dad have wanted? And you can imagine if you're having to make these types of decisions, it's a very difficult, very emotional time for a family. So the more clarity that can be provided through legal documents, absolutely the better outcome we're going to see for a family, and the less discord and less potential for arguments, discord, etc. In Arizona, we have something unique called a mental health power of attorney. And that is a document that says if the patient needs inpatient psychiatric hospital level treatment, the agent can get them in, get them the treatment they need, and get them out. And we will not ever need a mental health court guardianship proceeding. So when I'm working with clients here in Arizona, I'm encouraging all of them to not only have the traditional health care, but also to have the mental health power of attorney. Because part of the point of having all of your estate planning documents in place is to keep yourself out of court, keep your family out of court. So why not have a legal document? If you never need it, great. But if you do, you're going to be really grateful it's there. So when I'm working with families, and let's say mom and dad have dementia, early diagnosed dementia. They're probably at the early stage, still competent legally to sign medical directives, powers of attorney. But persons with dementia statistically may have behavioral issues. And as it progresses, as Stephanie, we could see a need for psychiatric care and treatment. And sometimes those behaviors are so extreme, we need the treatment in a hospital clinical setting. So all of my clients who have a dementia, a brain injury, a cognitive impairment, Alzheimer's, dementia, Lewy body dementia, Parkinson's, which often can have dementia associated with it, really want those patients, those clients, to have a mental health power of attorney. It's just absolutely the way to go. And then the last document for medical decision making I always recommend is a HIPAA release. Most people are aware that your doctor is not supposed to tell anybody anything about your medical care, treatment, and diagnosis unless you authorize the release of that private medical information in writing. So again, you're the adult child. You do not get to talk to mom and dad's doctor. They can't share information with you, not because they don't want to, but because the law prohibits them from, unless your parents have signed a medical release. That medical release, if it names you, means you can talk to mom and dad's doctors, get information, help, distill, gather information, schedule appointments, talk to the nurse if they're in the hospital. It means free flow of information, both while mom and dad are competent and they're still making their own treatment decisions, but you're helping. So I call that committee work. When the family's working by committee at the hospital, HIPAA release is very valuable.
Now, can they go through the medical providers? Oh, sorry, Stephanie. Can they go through the medical providers to do the HIPAA release, or is that something that they need to do with an elder law attorney?
It's best if you do it with an elder law attorney. And the reason is we are going to prepare what I'm going to call a global HIPAA release. It works everywhere. The hospital, the pharmacy, the doctor's office, surgery center. If you sign a HIPAA release at your primary care doctor's office, it works for that primary care doctor's office, but that release doesn't also work at the hospital, the pharmacy, the dentist. So we do one global that works everywhere. Yeah, great question.
And what happens if they've set up their living will, they have their power of attorney, and they realize, wow, we didn't do these two things? Is it an easy phone call, set up a meeting and get those documents done?
Yeah, we review existing estate plans all the time to make sure that they're complete. So I will tell you, in Arizona, for example, our mental health power of attorney is unique to Arizona. So if mom and dad, maybe they were snowbirding for a while, they moved to Arizona full time now, and they've got Minnesota state documents. Well, they're not going to have Arizona's mental health power of attorney. So we're always reviewing either old Arizona documents or out-of-state documents to make sure that they're valid, they're complete, and they have all the bells and whistles we want to see now based on the circumstances at present.
Well,
Yeah.
certainly if there's a new medical diagnosis or change in condition of any kind, I would
Yeah.
imagine you would encourage families, hey, let's review the documents and make sure
Abs
they have everything they need.
Absolutely. That's a really good, I'll say, time marker. If, we've had a recent hospitalization, new medical diagnoses, decline of some kind of an existing condition, it's a really good time to get in with an experienced elder law attorney, get everything reviewed because they have to be competent, legally competent to sign documents. So if we lose our window of capacity, I can't sign the documents. You can't sign the documents for your parent. They have to sign. And I can't tell you how many times a year we get a phone call that goes something like, I need power of attorney for dad. My team asks some questions and we find out dad's in a medically induced coma at the hospital. Well, dad cannot sign a power of attorney. So if your parent becomes incapacitated and we don't have good documents in place and you need to step in and pay their bills in particular, and there's no financial power of attorney, which I'll expand on in a moment, the only tool in my legal toolkit is court. Then we're going to have to go to court and get somebody appointed as the conservator for dad. I can tell you having dad sign a simple power of attorney was a whole lot easier and a lot less expensive than a court proceeding is going to be, because not only do we get you appointed, but then we're before the court for the rest of dad's lifetime usually. So it can be a very expensive process and a bunch of strangers, a bunch of lawyers, a judge. Everybody gets to know everything about everything. That's not what families want. So
Right.
it's much better to have everything managed privately through legal documents. So we covered medical directives. I gave a little hint, a little preview on power of attorney. So I do want to talk about that. Financial power of attorney, critical, because again, your parent becomes incapacitated, or as I like to say, they're still with us, but they're not with it. And they're not, everybody gets it when I say it like that. And they're not able to manage their assets, pay their bills, handle investment accounts, buy, sell real estate, sign contracts on their behalf. They're just no longer able to do those tasks. You don't get to do it. And guess what? If you're married and your spouse becomes incapacitated, you do not get to handle your spouse's financial matters just because you're married either. That's a big shock to spouses. So it's critical that everybody, if they're a legal adult, has a durable financial power of attorney. It can be in effect immediately. So let's say you're the adult child and you're actively working with mom and dad and you're on the phone with their financial advisor, you're helping to pay the bills, right? You're already involved. Then we would want their power of attorney to be effective immediately. But let's say you're just the proactive adult child and you're like, oh my gosh, I want to make sure that if something happens, I'm going to be able to step in and handle things as quickly and easily as possible for mom and dad. Mom and dad could just sign a power of attorney that only goes into effect when a doctor certifies in writing that they are at that point no longer able to handle financial matters. We call that a springing power of attorney. So you don't have to give authority away today. Mom and dad are private. They don't want to put you on the accounts. They don't want you to know what's going on. That's great. They don't have to, but they should have a power of attorney that says in the event they are not able to handle their matters, who is the agent that then will be able to do, because then we can stay out of court. So those documents are really important, and most traditional estate planning attorneys don't focus on that. They focus on wills and trusts, the documents that we use to say, how is the estate going to be handled and administered after somebody passes away? But as an elder law attorney, I see a ton of families get tripped up and a lot of problems get triggered because they don't have the good medical directives and a durable power of attorney in place, and we've got a health issue that's creating problems for the family, for the
Of
kids.
course. Yeah, and they don't know, you just don't know what you don't know. That's why this
Right.
education is so important.
Yeah.
Another thing that really gets confusing to the families that I've worked with over the last 25 years in the medical field is they don't understand the difference between medical power of attorney, financial power of
Yeah.
attorney, durable power of attorney. So could you quickly just highlight those three, explain the
Sure.
differences, and what's the best one to have if it's just one person?
So quick answer, you want all of them because they each
Okay.
serve a different purpose. Healthcare power of attorney says who gets to make your medical decisions if you cannot communicate your medical decisions yourself. Financial power of attorney and durable power of attorney really are one and the same. So you'll see sometimes the term general durable power of attorney, that is really the same thing as a financial power of attorney. The word durable means it's in effect throughout your entire lifetime. If it's not durable, then if you lose capacity, the power of attorney expires. Nobody would ever want that. So everybody wants a durable, what I'm going to call a durable financial power of attorney. It's in effect throughout your entire lifetime, whether you're competent or incapacitated, until you revoke it or you pass away. That's how that works. So you need both, because you need the medical and the financial, and you do not have to name the same person. Let's say one child is a nurse and one child is a financial advisor, and parent likes both kids and both kids can get along, right? It's the unicorn family. Mom may say, I want my child who is the nurse to be my primary decision maker under the healthcare power of attorney, but I want my child who's the financial advisor to be the primary agent on the financial side. And if I become incapacitated, I understand they're going to work together as a team, each wearing their respective roles, right, to work for me and to handle whatever is going to come up. Yeah. So you should have the healthcare and a financial power of attorney. They are generally two separate documents, just how they're drafted. You need to live in the HIPAA, the mental health power of attorney, to complement that healthcare power of attorney. And then we talk about the last will and testament. Most people know what a will is, right? A will simply says who you nominate as your personal representative and how you want your estate distributed, to whom, the individuals or the charities, after all the bills and debts have been paid. Wills do not avoid probate. That is a huge myth. Wills just say where your assets are going to go. But oftentimes with a will, we end up needing to open up probate. And the reason is the personal representative that you name, also called an executor, doesn't have any legal authority to take that will and start opening estate accounts, selling property, and handling the estate. They're nominated, but they don't have a legal authority to act until the will goes to the court, and the court admits the will in a probate proceeding and issues what's called letters of administration. So a will will get your assets from point A to point B, but we're often going to have a court oversight process involved. Most people know they want to avoid probate. They don't even know why. They just know probate's bad.
Right.
It's expensive. It's not private. Takes more time, takes more money. Lots of reasons why families would want to avoid probate. To avoid probate, our number one legal tool is a trust. A revocable trust avoids probate because the assets that are owned by the trust says if you pass away where your assets go, and trust law already gives the authority to the trustee to do the work. So we don't need a court order because trust law works different than probate law. So with a trust, it functions, most revocable trusts, the type of trust I'm describing, functions like both a financial power of attorney and a will. Because if it's your trust, you put your property, your assets, your accounts into the trust, you retitle from you to the trust. You normally put yourself in charge, right? As the trustee, the person who's managing the assets for your benefit during your lifetime, but you name a successor to say, in the event I'm not able to pay bills because of an accident or an injury, here's my successor. They take over and manage everything for your benefit during your lifetime. Same job the agent under the power of attorney does, only now they're wearing their trustee hat. If you pass away, the trust then says, now my trustee is going to marshal my assets, pay my debts, and distribute the trust estate as follows. Exact same thing the will would have said, but it's a smoother, quicker, and more private process because we don't have the court involved. So trust for a lot of families are the way to go. It's just going to depend on goals, objectives, and what you own. And that's why you always want to sit down with a lawyer who can look at everything, all of the assets, the type, the amounts, talk with mom or dad or you, if you're the client, about what your goals and objectives are, and make a recommendation as to, is a will-based plan going to work, or is a trust-based plan better for you? But that's, estate planning isn't cookie cutter. It's unique to everybody. Every family is different. And so we bring in the right legal tools, whether we're using a will-based or a trust-based plan. You're always still going to have the suite of medical directives and the durable financial power of attorney too.
Okay. And so that takes me back to where the majority of my clients are when they call me is we're in a crisis.
Yeah.
And we have to do all of these things for them in a very short period of time. So what happens if there's a crisis and they don't have these documents already in place? What does it look like for that family?
Yeah. First off, it's a lot more stressful, right? Because they need to do things and they can't, right? Because they don't have the right legal authority and the right legal documents. So if there's a crisis and mom or dad still has legal capacity, right? I've done plenty of hospital signings, skilled nursing facility signings, assisted living signings. Sometimes we wait through the medical event to subside, a little bit of recovery, and then we get out there and get the things signed. But if we don't have legal capacity, let's say it was a major stroke and they're not legally competent any longer, they can't sign documents if they're not able and willing and they can't understand the documents. So then we're going to be stuck going to court. 9 times out of 10, we're going to have to get a guardianship in place and a conservatorship. Guardian is when the court appoints an individual or an entity to make the personal and medical decisions for an incapacitated adult. A conservator in Arizona is the terminology we use when the court appoints an individual or an entity to handle all the financial matters for an incapacitated adult. Guardianship and conservatorship is a wonderful tool. If we have to use it, we have to use it. But it's much better if we have pre-planning, if we can get the documents. And so the number one thing I can tell the adult children and talking to parents is ask them if they've done their estate planning. If they say no, really encourage them to consult with an elder law attorney to learn what they need to know. Because most parents don't want to make things more difficult than necessary on their kids, right? And so mom and dad may not be worried about it, but you may be. And so maybe it's, hey, mom and dad, go see a lawyer so that I know everything is okay. So if anything ever happens, I'm going to be able to step in and help. I'm going to be able to be there for you, or somebody's going to be able to be there for you. Because sometimes parents don't care about themselves, but they do care about their kids, and they'll do it for their kids. The other thing I can say to families is, hey, mom and dad, you want to be in control. You want to pick who's going to take care of things for you. How do you want that taken care of? If you need care, do you want it at home? Do you want to move with a kid? Or how are we going to pay for it? So lots of things an elder law attorney can work with the family on and planning. So if mom and dad like to be in control, right? They need estate planning documents to say how they want things to go. Because if I have to go to court, maybe the judge picks the person to be in charge that mom and dad would have picked, but we'll never know because mom and dad didn't pick.
Yep.
That's what happens. Yeah. And then if somebody dies and they don't have estate plan, wills or trusts in place, our legislature has made a will for you. And people aren't aware that our legislature has put laws in place to say who inherits your estate if you don't have a will or a trust when you pass. So it may not be the people you want, may not even be people you like, but that's who's getting it. So it's far better that you say who inherits, how you want that to go, who you want to handle things, medical, financial, even on the estate side, than to leave it to chance.
No, such great information. Thank you. Because these topics are oftentimes overwhelming and everybody is busy with life. We'll get to it. We'll get to it.
Oh,
and
yeah.
Unfortunately, sometimes when you're in a crisis, it's not what you planned for. We want to provide as much information for our families so that they can make those decisions so that when they're in a crisis, they know everything's going to be handled exactly the way that they've decided it should be. And then the adult children can just be the adult children, right? They can be there for mom or dad, help with their care, make sure bills are paid while they're in the hospital or recovering from a surgery, whatever the case may be. Stephanie Bivens, thank you so much. And to our guests, we're going to have future episodes because there are so many topics where she's an expert. So stay tuned for those future episodes. Thank you again, Stephanie.
Thank you.